Clerk, please publish the verdict.
Yes, sir. In the Circuit Court of the 11th Judicial Circuit in Miami-Dade County, Florida, State of Florida versus George P. Case number F24-22896. Judge Marisa Tinker-Mills. Verdict. We, the jury, find unanimously as follows. As to count one of the information, manslaughter of Luciana Cristina Fernandez, the defendant is not guilty. So say we all on this 22nd day of June 2026, signed by the foreperson, CF. In the Circuit Court of the 11th Judicial Circuit in Miami-Dade County, Florida, State of Florida versus George P. Case number F24-22896. Judge Marisa Tinker-Mills. Verdict. We, the jury, find as follows. As to count two of the information, vessel homicide of Luciana Cristina Fernandez, the defendant is not guilty.
So say we all. 4 words, read aloud in a Florida courtroom on June 22nd, 2026, signed by the foreperson, delivered on behalf of every person who sat in that jury box for 3 weeks and listened to everything the state of Florida had to offer.
Clerk, please publish the verdict.
Yes, sir. In the Circuit Court of the 11th Judicial Circuit in Miami-Dade County, Florida, State of Florida versus George P. Case number F24-22896.
Not guilty. On both counts. The state had charged George Pino with vessel homicide, a criminal accusation that, in plain terms, means the prosecution believed he operated a watercraft in a manner so reckless, so criminally negligent, that it caused another person's death. Vessel homicide in Florida is not a minor charge. It carries the weight of a felony. It carries the weight of prison. And it carries the weight of a name. Luciana Cristina Fernandez, listed in the formal charging document as the person whose death the state believed George Pino was criminally responsible for. The state built that case. They presented it. For 3 weeks, attorneys stood before that jury and argued that George Pino should be held criminally accountable for what happened on that water. And when the jury came back, they did not take very long. Here is what I want you to think about before we go any further. A criminal trial is not a conversation. It is not a debate where both sides make reasonable points and the jury splits the difference. It is a one-directional burden. The state must prove guilt beyond a reasonable doubt. The defense does not have to prove innocence. And that means that if the prosecution's case is not strong enough, it doesn't make them prove. It makes them acquit. Anything. The defense does not have to present a single witness, a single exhibit, or a single argument. The defense simply has to stand in the room while the state fails to meet its own standard. That is what a not guilty verdict means. It does not necessarily mean the defendant is innocent in any philosophical sense. It means that 12 people, chosen through a selection process both sides participated in, sworn to follow the law, and sequestered from the noise of public opinion, looked at everything the state presented, and concluded that it was not enough. Not enough to meet the legal standard. Not enough to justify taking a person's freedom.
All right, there are no holds in Mr. Pino, is that correct?
Correct.
All right, ladies and gentlemen, if we would give the jury a few moments, please, to exit exiting the courtroom and the courthouse. And I want to thank everyone again for your respect for this court. We'll take a moment now, and I have no further matters.
There are no holds on Mr. Pino. Is that correct? The defense confirmed. Correct. Now, let's talk about how we got here. And more importantly, let's talk about what this verdict quietly reveals about the case that preceded it. The charging document, called an information in Florida criminal procedure, which simply means the formal written accusation filed by the prosecutor, rather than by a grand jury, listed 2 counts against George Pino, both connected to the death of Luciana Cristina Fernandez, both argued under the vessel homicide statute. The prosecution's theory was that what happened on that watercraft was not an accident in any legally meaningful sense, that there was criminal culpability, that the evidence would demonstrate that culpability clearly enough for 12 strangers to agree, unanimously, beyond any reasonable doubt. They were wrong on both counts, unanimously.
In the Circuit Court of the 11th Judicial Circuit in and for Miami-Dade County, Florida, State of Florida versus George Pino, case number F24-22896, Judge Marisa Tingley-Ramirez. Verdict. We, the jury, find as follows. As to count 2 of the information, vessel homicide of Luciana Cristina Fernandez, the defendant is not guilty.
The word unanimously is doing significant work in this verdict, and it deserves your attention. A Florida criminal jury verdict must be unanimous. That is the constitutional requirement. Every juror must agree. Which means the state of Florida did not simply fail to convince the jury. They failed to convince a single juror on either charge. Not one person in that box, after 3 weeks of testimony and evidence, found the state's case sufficient to meet the legal standard for conviction. That is a particular kind of outcome. It is not a close call. It is not a split that fell the wrong way. It is a unanimous finding that the evidence the state presented did not rise to the level the law requires. Think about what 3 weeks of trial looks like in practice. Jury selection, opening statements, witness examinations, cross-examinations, expert testimony, almost certainly given the technical nature of vessel homicide, physical evidence, closing arguments. 3 weeks means the state had time, real time, to build something substantial. And when the jury came back, they dismissed both counts. This is where I want to pause and ask you something directly, because it is a question worth sitting with. At what point in a prosecution does an attorney have an obligation to reassess whether the evidence actually supports the charge? That question does not have a comfortable answer, but it is the question this verdict quietly poses. If you have a thought on that, the comments are a reasonable place to put it. The judge's conduct after the verdict is worth examining on its own terms. When the jury returned, the judge presided over the polling, a process where each juror is asked individually to confirm their vote. Ladies and gentlemen, I call your name. Please answer yes or no. One by one, the jurors confirmed.
Ladies and gentlemen of this jury, you heard me read the verdict. As I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Mr. A.L., initials A.L. Yes or no?
Yes.
Initials C.F. Yes. C.S.
Yes.
L.M.
Yes.
J.M.
Yes.
Every single one of them. It was not a formality performed for the record. It was the record. Each individual confirmation is a data point, and collectively, they produced the same answer 12 times in a row.
Clerk, please publish the verdict.
Yes, sir. In the Circuit Court of the 11th Judicial Circuit in and for Miami-Dade County, Florida, State of Florida versus George Pino, case number F24-22896, Judge Marisa Tingley-Ramirez. Verdict. We, the jury, find unanimously as follows. As to count 1 of the information, manslaughter of Luciana Cristina Fernandez, the defendant is not guilty. So say we all on this 22nd day of June 2026, signed by the foreperson C.F. In the Circuit Court of the 11th Judicial Circuit in and for Miami-Dade County, Florida, State of Florida versus George Pino, case number F24-22896, Judge Marisa Tingley-Ramirez. Verdict. We, the jury, find as follows. As to count 2 of the information, vessel homicide of Luciana Cristina Fernandez, the defendant is not guilty. So here we all, on this 22nd day of June 2026, signed by the foreperson C.F.
Does counsel for either the state or the defense wish for the jury to be polled?
Yes, Your Honor.
Madam Clerk, please poll the jury with initials.
Yes. Ladies and gentlemen of this jury, you've heard me read the verdict. As I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Mr. A.L., initials A.L. Yes or no?
Yes.
Initials C.F. C.S.
Yes.
L.M.
Yes.
J.M.
Yes.
After the polling, Judge Marisa did something that receives very little attention in post-verdict coverage of criminal cases, and it reveals more about the architecture of the system than most procedural moments do. She turned to the jury and spoke to them about their rights.
Ladies and gentlemen, I want to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work.
Not their verdict, their rights. She told them that no juror can ever be required to discuss what happened in that jury room except by court order. She told them that for centuries, society has relied on juries to consider difficult cases, and that the deliberations, the discussions, the votes, those belong to the jurors, privately, for as long as they choose. She told them they were free to speak to anyone, including members of the press, including the parties, including curious strangers. But she was equally clear that they were free to speak to no one, that the privilege was theirs, that any request, from whoever made it, for whatever reason, was theirs to answer or decline.
A request may come from those who are simply curious or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror.
This is not boilerplate. Every word of those instructions was legally precise, and the reason they matter in this case is that a vessel homicide acquittal, particularly after 3 weeks of trial, produces a particular kind of pressure on jurors. Somebody died. There is a grieving family. There is public attention on the outcome. And the state, having invested 3 weeks and presumably significant resources in this prosecution, now has nothing to show for it. In that environment, jurors sometimes face questions they did not expect, from people they did not anticipate having to speak to. The judge understood this. The discharge instructions were not perfunctory. They were protective.
I want to thank you all again for the sacrifices that you have made over the last 3 weeks, for your time and consideration in this case. What I have for each one of you is really just a token of our appreciation, which is a certificate of appreciation, and a small symbol of the great appreciation all of us have for you and for your participation in our...
And they were delivered with the quiet authority of a judge who knew exactly what she was doing.
All right? I'm going to ask everyone, please, in the courtroom to please remain in the courtroom for a few moments and allow the juries to exit. Thank you.
All rise.
Here is where this case gets genuinely interesting. And I want you to stay with me on this point, because it is the thing that most commentary on criminal acquittals gets wrong. The verdict tells us what the jury decided. It does not tell us why. The deliberations are sealed. The reasoning behind each vote is private property, belonging to 12 people who are under no obligation to explain themselves to anyone. The 4 persons signed the verdict form.
Found not guilty as to both counts of the information in this case. Are there any other matters involving Mr. Pino? for this court to address.
Not for the state.
Anything else?
That signature is the full public accounting of what happened in that room. Everything else, every theory about what evidence proved dispositive, every speculation about which witness the jury found credible, every analysis of why both counts failed, is exactly that, speculation. What we know is this. The state charged a man with 2 counts of vessel homicide. They tried the case for 3 weeks. They presented their evidence. They made their arguments. And when the foreperson read those 4 words, "So say we all," the state's case was over. Completely.
Found not guilty as to both counts of the information in this case. Are there any other matters involving Mr. Pino
Not for the state.
for this court to address?
Not for the state.
Anything else? All right, there are no holds in Mr. Pino, is that correct?
Correct.
All right, ladies and gentlemen, again, if we would give the jury a few moments, please, to exit exiting the courtroom and the courthouse. And I want to thank everyone again for your respect for this court. We'll take a moment now, and I have no further matters.
On both charges, without a single hold placed on the defendant, without a single post-verdict motion disturbing the outcome. The criminal justice system is, at its core, a machine designed to answer one question. Did the government prove what it claimed to have proven? To the standard the law requires, beyond a reasonable doubt. In this case, the machine produced its answer, and the answer was no.
Mr. Pino, the jury is found not guilty as to both counts of the information in this case. Are there any other matters involving Mr. Pino
Not for the state.
for this court to address?
Not for the state.
Anything else? All right, there are no holds in Mr. Pino, is that correct?
Correct.
All right, ladies and gentlemen, again, if we would give the jury a few moments, please, to exiting the courtroom and the courthouse. And I want to thank everyone again for your respect for this court. We'll take a moment now, and I have no further matters for me to address, and at this time, we are at a recess. Thank you.
Now here is the legal lesson I want to leave you with, because it is one that matters far beyond this courtroom and this verdict. The burden of proof in a criminal case is not distributed equally. It is entirely, exclusively, and non-negotiably the state's burden. That is not an accident of legal history. It is a structural choice, a deliberate design decision embedded in the American legal system that reflects a value judgment. It is worse to convict an innocent person than to acquit a guilty one. That asymmetry is the foundation of every criminal trial, and the standard, beyond a reasonable doubt, is deliberately set at a level that is difficult to reach. Not impossible, but difficult. When a jury returns a not guilty verdict, a segment of the public often interprets it as a failure of the system. Something went wrong. The jury got it wrong. The defense found a technicality. But that framing gets it backwards. A unanimous acquittal after 3 weeks of trial is not a malfunction. It is the system functioning as designed. 12 people, who had access to every piece of evidence the state chose to present, applied the standard the law requires and concluded that the standard was not met. Whether the state made the right charging decision in the first place is a separate question. Whether the evidence existed to support a conviction is a separate question. Whether this outcome serves justice in any larger moral sense is a question the legal system is not designed to answer. The legal system is designed to answer one question only, and it answered it. George Pino, case number F24-22896, 11th Judicial Circuit, Miami-Dade County, Florida. Not guilty. So said they all.